Well, first of all, another G4S employee is appearing before the Bloemfontein Magistrates Court this morning, been arrested for helping, allegedly, the escape of Thabo Bester from prison. Police say the 51-year-old was arrested yesterday at the Mangaung Correctional Centre. Well, senior reporter Slindelo Masikane there for us now, taking a look at what is expected as well. And Sli, hello to you. So I would imagine we're starting to get a sense as a country the net is starting to tighten around those who've been implicated in the Thabo Bester escape.
Well, you know that law enforcement has been under immense pressure not only to return Bester as well as Dr. Nandipa back into South Africa, but to also start reining in on those who've been implicated and played a part in the escape saga. Now, as the media, we've had to make a fresh application in order to bring those proceedings live to our viewers. Quite tight security, I must say. We've all been given wristbands, and then if you see to my right, you can also see that we've got security officials who are manning the particular hallway to the courtroom in which we will be seated in for those court proceedings. And you would know that it is the first court appearance. We're not really expecting it to start at 9 a.m. this morning, but we are expecting the docket to perhaps make its way to the courthouse by around 11 o'clock. We know that the accused is a security guard who was manning the gates of the Mangaung Correctional Centre, either on the day of the escape or on the day in which the body that was planted in Bester's cell was brought in. They are facing charges of defeating the ends of justice as well as aiding and abetting a convict. But to just give us more analysis in terms of what we can expect today, I am joined by legal expert Marius du Toit. Thank you so much for your time this morning, Mr. du Toit. Maybe let's just start with those charges, aiding and abetting as well as defeating the ends of justice. If I'm not mistaken, these are Schedule 1 offences. Just how severe are these charges then in terms of the escape saga in totality?
Morning, Slee. Always lovely speaking to you. Firstly, let me say, when you talk about defeating the ends of justice, it is typically a Schedule 1 offence. It's not a Schedule 5 or 6 offence, which means that the state normally would have to show grounds in the interest of justice why you should not be permitted to bail. But having regard to the gravity of the offence, we have to say that the offence itself will lean itself to the fact that the state will in all probability oppose bail, depending on the evidence which they have to their disposal. I mean, the difficulty is each matter is considered on its own merits. But let me just say, when you talk about sentencing, defeating the ends of justice, I was quickly looking up this morning before I came on air, and it would seem that the courts give anything from 18 months to about 4 years imprisonment for defeating the ends of justice, depending on the gravity of it. When you deal with the offence of aiding and abetting a person in escaping from lawful custody, that's a different kettle of fish. Now you're dealing with the Correctional Services Act, and that dictates that you can impose a sentence of up to 10 years imprisonment for that. So without a doubt, if this person is convicted, having regard to the gravity of this offence, having regard to the circumstances, I have no doubt that this person will be facing direct imprisonment. So the charges are serious. It's not the type of a matter where ultimately the person would go to jail for 20 or 30 years, but it's definitely a matter where you will be going to prison if you are convicted.
Maybe then let's talk about the likelihood that this particular suspect will most likely then join the 4 others that have been implicated and charged. We are expecting bail applications on the 3rd and the 4th of May. So in terms of what we can expect today, surely it should be, short proceedings in terms of legal representation and just presenting the charges to the court.
Yeah, Celine, I absolutely agree with you. If bail is not being opposed by the state, they will definitely grant bail on the first appearance. If, however, the state has any intention of opposing bail, which I expect they will do, then they'll probably postpone this matter to the same date as the other 3 accused so that they can have one bail application at the same time for everybody, because the 3rd of May is around the corner. It's not that far. So I have no doubt that they will then try and put them together, because it's just easier for the state to have one bite at the cherry and not 5 bites at the cherry. That being said, due to the fact that you are dealing here with a person escaping from lawful custody, and the fact that these individuals are all aiding and abetting or assisting in that process, you have to say that just the nature of the offence is of such a nature that the state will do everything in their power to oppose bail if they have strong evidence against this person. Because remember, at the end of the day, we have a duty to ensure that people that are sentenced are kept in the facilities. And we as the public have a right to expect that from the prison authority. So when somebody comes before a court who has not only worked in these facilities, but has aided somebody to escape that was serving 2 terms of life imprisonment, and thereafter the person in the process of escaping is now also murdering an unknown individual, you can understand that the gravity of this is such that the state might say, number one, you might have the means to evade justice, you are involved in a serious offence, and in all likelihood you may be a person that will not stand his trial. So at the end of the day, these are all factors the state would consider, especially if they oppose bail. But if I ever, like with the father, Mr. Kulile, if they find that, listen, we don't have really much against them, then they might not oppose bail, but I somehow think they will oppose bail.
Lastly then, Mr. du Toit, my sources have been telling me that those who have been implicated, some of whom have been arrested, are singing like canaries, implicating others in this particular matter. Is this in a way trying to perhaps, have the courts show mercy on them, or perhaps be able to get reduced sentences if they're found to be guilty?
Yeah, absolutely, Slee. If you're facing direct imprisonment and you understand that if I don't make some sort of a disclosure, chances are if I'm convicted, if the evidence is overwhelming against me, then you often find that the accused will come forward and say, listen, can't I cut a deal? And often cutting a deal will mean that I implicate the other people. I'm able to to fill in the holes for the state that might exist at this stage. And then, of course, in doing so, I might benefit the state in the prosecution of the other accused. And typically speaking, if a matter is serious, either the state can do this by entering into a plea deal with that accused, saying, listen, instead of giving you 6 years, we're going to give you 2 years, but you testify. You often find in farm murders or murders of individuals, when you talk about cash in transit and stuff like that, you often find that one accused will implicate the others. And then instead of getting life imprisonment, by cutting a deal, he would get 20 years imprisonment. So he'll still serve time, but it's just that he now doesn't get the implications of a life sentence. And so that's one way of looking at it. The other way of looking at it is the state could say, listen, because of the information that you have, we're not going to enter a plea deal with you, but we're going to use you as a so-called Section 204 witness. And that's where you testify at the behest of the state. If you testify satisfactory in all material respects, then the court will grant you immunity from prosecution thereafter. But having regard to that, you have to say this is a co-accused testifying against the others, so there's all the incentive for him to lie. And that's, of course, a factor that the state would have to take into consideration. So weighing up whether entering into a plea deal or whether using the person solely as a witness is something the state will carefully weigh up. But typically speaking, if you talk about direct imprisonment plea deal, it might be something that carries more weight for the state when that person testifies, because there's no benefit for him now in testifying other than the fact that he's already been sentenced.
Thank you so much for your time this morning. That is Mr. Marius du Toit, a legal expert, just unpacking for us what we can expect from proceedings this morning.